So welcome, everybody. My name is Kit Needham. I am the director for Project Olympus, which is a startup incubator program for Carnegie Mellon, also assistant dean for entrepreneurship initiatives. And we've been doing these Start Smart series in cooperation with the Pitt Law School. I'm going to introduce Stephanie in a second, or let her introduce herself, for a number of years. Hopefully we're addressing topics that are of great interest to you. So just what we do at Olympus, we help faculty, students, staff, alumni, actually Pitt students, we're not particular, that explore the commercial potential of their innovation or their ideas and find product market fit and a feasible business model. So Stephanie, you want to introduce yourself?
Sure. I'm Stephanie Dangle. I'm a professor of practice at Pitt Law School. Many years ago, I practiced with David at K&L Gates. And now I'm thrilled to see that one of my students is now practicing with David. I'm not sure. Hello, Carrie. So I teach transactional drafting, commercializing new technologies, entertainment law, and a cool new course called Wicked Problems Innovation about vacant lot development in the Hill District. So, but I've always enjoyed these Start Smarts. I learn something every time I sit in. So glad to be back.
So Rhonda, are you in a position where you can unmute? Okay, good.
Yeah, sure. Hi, I'm sorry you can't see my face right now. I'm driving, so it'd be a weird angle. But for those of you who don't know me, I'm the director of the Big Idea Center at the University of Pittsburgh. We are Pitt's hub for student innovation and entrepreneurship. That means we support primarily the student entrepreneur, but a lot of the work that we do with those students intersects with faculty and university intellectual property. We partner a lot with Carnegie Mellon on a number of programs. Our students intersect on teams across the institutions as well as other organizations. So we're thrilled to be a part of this series that our CMU and Pitt Law have helped develop. And again, this is this whole effort for the Smart Start is really addressing all of these questions and issues that so many of our teams have. So happy to be here, and also happy to make sure that you know Isaac, who is part of our organization, who helps us carry this effort out smoothly.
So Tiffany, are you in a position where you can just say hi? So Tiffany is the train master that keeps the trains on the tracks and keeps them running. So she is our host and manages the Zoom meeting. So she's part of the Big Idea Center, and we're happy to have her. So, okay. Now, so I'm going to turn it over to David and Chip, and you can introduce yourself.
Are you doing your other thing first?
Oh. Thank you for reminding me that. Okay, this is part of what we call the Connects series. And the reason is it helps those who are looking for, got a project and you're looking to have other people join your project. You don't have an idea, but you wouldn't mind working with or helping out somebody who is actually working on an idea. You have an idea and you need some advice or help. Or two, that you have an announcement, like you're going to do a launch or you need volunteers or whatever. So this is an opportunity for entrepreneurs to meet each other and to link up and tap into each other. So the way this works, you can just unmute yourself, give your name, and just say briefly what you're doing, and then say what you're looking for. And I'm going to pick on somebody here, just to, even if you don't need something, just to get the things kicked off.
I can go real quick if you want.
Oh, go ahead. Go for it. Great.
Hello, my name is Nicole Korber. I'm a student at Tupper's MBA program. And I have an app I developed with the Department of Human Computer Interactions hackathon program last year. And there's been some talk about what to do with it. It's mostly focused around accessibility and in that market. And I'm looking to see what my next step should be, because I'm telling a whole lot of people about what I did, and it's a little, I'm not ready to launch it yet, but I kind of want to figure out what to do in the meantime. And I'm also I would love to connect with some engineers who have familiarity with audio hosting. And I also, a lot of what I'm doing is surrounding copyrights and publishing audio files. So yeah, I'm looking to find more out about that, if that makes sense. Thanks.
Definitely carry, toward the end of that too. So Nicole, why don't you put your contact information in chat so people
Sure.
can know how to follow up with you. And if you just want to do a little bit, want to add a little bit more, remind people what you're looking for.
Sure, thank you.
Great. So you see how it works. And I bet Nicole will get somebody that will help her tonight on at least some of those things. Anybody else want to do a shout out?
Sure, I can go next. So I'm Vishal
Okay.
Razgutta. I am an MBA candidate at CATS, but I'm working for a PIT seed funded project called the CivBase. It's basically an app which allows people to raise awareness, or students to raise awareness, and also test their awareness on civic and social quotient, I would say. And so we actually developed the app. We did a pilot run in the PIT campus. It went well. We've heard good feedback, but now we are looking at commercializing it and also releasing it to other campuses in Pittsburgh. And that's one of the objectives. And the second objective is to commercialize it so that we could start utilizing or selling some of the data that we gather from and the insights that we gather through the app to businesses or universities, and helping them take certain initiatives around some of the key items. So we realized that legal would be something that we would need to pay close attention to, and so here we are.
Oh, good, welcome.
So do you have anything particular that you're looking for, other than if somebody's interested in your idea to follow up with you?
So basically seek help for how to go about the legal aspect of commercializing the app, like what are some of the things that we have to be mindful of if we wanted to release it to the public and then sell the data. What would be the legal implications around it, and how could we better prepare for it? So
Okay,
yeah.
That's great. So I'm sure David's taking down notes. And Chip is, by the way, is an IP attorney, so we're doubly covered here. So anybody else?
I could speak real quick.
Okay.
My name is Sean Andres. I'm a CMU student in the music entrepreneurship program. My business, Pyro Percussion, is instrument manufacturing. I'm focusing on eco-friendly and sustainable materials to use for percussion instruments. Right now, I'm going through the process of compiling resources for a provisional patent, and within the next year, hopefully looking to file the non-provisional. Yeah.
Okay, well, thank you. Yeah, he's also part of our new program called the Customer Discovery Kickstarter, just started last night. So good to see you, Sean.
I can jump in here. Hi, I'm Philip Verlander. I'm working at a company, or working with a company called Lycotech, and we do non-invasive intracranial pressure sensing. One question I had actually is about visas for international. So I'm a foreign national. I need to figure out how my OPT can be transferred to a STEM OPT potentially through the company, or other employment options, in the near future.
So we don't handle visa issues as much. We have another Start Smart that we do sort of mid-year, Philip, that talks a little bit more about that, because I know immigration is an issue for a number of students, but I can help you offline on that.
Okay, excellent. Thank you so much.
Anybody else?
Hi, my name is Lisa Kiefer, and we have a startup for some medical software. And right now we have 2 products, and we have investors who are interested in one product. So we're wondering how to split the company to align each product with each investor.
Got it. Okay, on the list. Thank
Interesting.
you.
Cool. Thanks, Lee.
Okay.
Actually, Kit, maybe we can make it more clear, which is your typically you do the connect thing, but this is broadened, which I kind of like, which is other things people would like to hear about this evening, because this presentation is a little less, not a little less, it's a lot less formal than our Start Smart, and we want to address what you're interested in. So if there are other areas, either speak now or interrupt us or et cetera, because otherwise you're going to have to listen to us pontificate about what we think you might be interested in. So
Okay.
while we're doing the interaction, you've already started. If there's other things you want to hear about, why don't we sort of hear about it, or
Okay.
you know?
So does anybody else have something specifically that they just showed up here tonight that they wanted to find out about?
Hearing none so far. But we'll keep going, and you should feel free to interrupt and please ask questions. Back to you, Kit, unless you want to.
Oh, no, actually, I was just about ready to turn over to you. So just anybody who has looking for either, to talk to people or wanting something to, you can put your information in chat. And
Cool. Well, let me first introduce myself. My name is David Lehman. I'm a partner with K&L Gates. Extraordinarily boring work history, because I've been with the same firm now for 37 years, which is just ridiculous. And I work with do all kinds of corporate work. As I always say, I do everything except go into court. But I like to work with startups and growth companies and technologies and all that good stuff. Chip, do you want to introduce yourself as well?
Sure, David. Chip Doherty. I've been at Carnegie Mellon for a little over 3 years now. I'm Associate Director of Intellectual Property. So that means I work with all the intellectual property that is owned by the university, created there, and along with a team of about 12 or 14, I forget what our current head count is, in the office of CTEC, so Enterprise Creation, Technology Transfer office here on campus. We do everything from managing our patent portfolio to licensing software to whatever we need to do to transfer technology that's created here and move it on to either a commercial platform or just out to the public so someone will take it, use it, develop it. My role there is partly portfolio management, partly strategy, education, faculty, staff, students, and a little bit of licensing, a little bit of enforcement with folks who are on the line tonight, like with Carol, who introduced herself earlier. So a long career as an IP attorney prior to that, and have worked with Kit in a couple of different roles over the last, Kit, 5, 6, 7 years. So.
right, he was one of our EIRs at one point. So
Thank you. So as I indicated earlier, this is very informal. And what we want to do is cover issues that you folks are interested in as it relates to startup companies, legal issues, that is. But there's a couple themes. So let me hit a couple themes, and I just thought questions regarding IP, so maybe we'll start there as well. But let me give you a theme. And the theme is that when you're doing a startup, it's important to have when you think about the legal aspects, to think about it in the long term. And my point there is to plan to be running your business, obviously to make money and to be successful and all that kind of thing. But also, you'll do pretty well if you think about it as a potential buyer and set it up for what's a buyer of your company going to be looking for. And I'll give you a couple examples. One is, have you protected have you adhered to the corporate formalities? Have you kept all the minutes? And we'll talk about corporate formation in a little bit, but have you done all the kinds of things related to that? Have you kept your trade secrets secret? And we'll talk a little bit about that in a moment. Have you protected your IP? An important one is when we talk about contracts, if you'd like to, are they assignable? I have a transaction right now where we're thinking about acquiring a company, but unfortunately, their customer contracts, they didn't negotiate very hard. Their customer contracts are not assignable. And and they will have to go back to all their customers or the principal contract customers and ask them for consent. And of course, when you ask for consent, I always say that means how much. So and so they really haven't set themselves up for an exit. And so if you have that window in your head, I think you'll do well as you continue on.
David, could I interrupt for a quick moment and just ask for clarification? It was not assignable because of the contracts that were established between the two organizations?
Yes. Yes. So contracts are they're contracts kind of neat because they are between two parties and they are what you agree to. And there's always a little tension because when I enter a contract with somebody, I want to know that, especially a service provider, I want to know that they are going to be the service provider, right? And so there's a little tension as to whether you can assign that contract or not. And this is an example of they are providing a SaaS service, and the customer wanted to make sure that the service provider was going to be the ultimate service provider, wasn't assigned to somebody else. And that is a legitimate, perfect concern for a customer, a significant commercial customer, but the issue is that if the supplier, in this case the vendor, wanted to sell the company, it's having trouble selling the company because they have to go back and get consent by the customer. And this works its way through a variety of contracts. And so you need to negotiate them, and it comes with, sometimes it's signing the contract, sometimes it's change of control. There's all different things. So I'm using that as an example of something you really need to pay attention to when you're contracting with third parties. So, answer? Cool. It's just an example of things to pay attention to when contracting and thinking about the ultimate exit. Similarly, for example, I mean, I've given the example of these things before of when an investor comes in. Excuse me, I got something in my throat. And the investor got an approval right, or early investor got an approval right over the sale of the company, which nobody remembered later. And they had a pretty good offer on the table, and the first investor said, "Oh, by the way, I don't want to sell," and everybody else did. And so they ended up diverting some of the consideration that would have otherwise gone to some of the other investors to that first investor in order to get their consent. That's the most extreme. So again, I'm simply suggesting that it's a very strange concept and it's counterintuitive. So as you're starting, I want you to think about the end. It's sort of the point from a legal perspective. And another one to think about as you're starting is the regulatory side. Some of the things I think people don't think about hard enough is what regulatory issues surround your business and whether you have those in place. And we'll spend a little bit of time on that, but I want to emphasize that, which is that there's a lot of regulation and it just gets more and more. And it comes on the city, state, federal, all different kinds of things. And if you're in a highly regulated area, you want to make sure that you're complying with it. So one of the things as you're thinking about your business plan up front is what regulatory regimes am I going to run into? And think about that up front because that adds cost. The good news is if you comply with it, if you get a bunch of permits and licenses and all that, it may actually create an additional asset for you, but it also can create costs. So that's another one to think about as you go forward. All right, let me go to something a little bit more, start with intellectual property. And because many of the companies that we deal with are technology oriented and IP heavy. And I like to frame this as, when I think about IP, in three different questions. Question one is, do I own the IP? Two is, am I infringing somebody else's intellectual property? And third is, have I protected the intellectual property? And those are three different concepts. On the first one, if you're starting a company, it's really important that you own the IP. And I'm gonna do the overview, Chip, and I'm gonna hand it to you because if you own the IP, that goes to licensing and getting out of the university, which is more your bailiwick. But it's really important that when you get in, for example, if your founders have not assigned the IP to the company, If you don't have employees, you have to have employees assign the IP to the company with present assignments. Independent contractors assign the IP to the company. Sometimes you check with your founders and see whether they have obligations to third parties. So maybe if they create it, they actually own it by somebody else. For example, professors at the university, if they create something that's owned by the university. So the point is, do I own it? Have I gotten somebody to assign the IP to me, to the company? 2 is making sure that you don't infringe somebody else's intellectual property. For example, it's not funny to find out that you're infringing somebody else's patent. We all have our stories to tell, and of course I have one on that one as well, which is a company which realized that its fundamental business was actually infringing a patent that the third party held, which isn't perfect. Actually, it's the opposite of perfect. But the only saving grace after a couple of sleepless nights is they could actually Chip, this is one business processes you could actually have patents on these things. But the good news is they could tinker with their business and get out from under that patent relatively easily, so that they could get around it. So one of the things I suggest, and I'd be interested in Chip's view of this, is to check around, particularly on patents, and see whether you're infringing somebody else's patent. And then lastly, protecting it. Every company ought to have, startup company ought to have some kind of a.
Can I interrupt again?
Yeah, please.
I've gone through this process, and it just might be helpful for others as well. But to follow up on your second point about infringing, where would you suggest they start to research that? The USPTO, would that be the find out if they're infringing on something else, or how would you suggest the first step for others so to protect themselves that way, that they're not infringing?
So I would suggest they check with the USPTO and do a patent search. But let me actually let Chip weigh in on that, because since he's an IP lawyer, why don't I let him weigh in on that, and I'll shut up.
No, it's you're right, David and Matt. So it's not a simple thing, right? It's like most things in the law. If you're worried about infringing on someone else's patent rights, then yes, the USPTO, you can do what's called a freedom to operate search, or have a professional searcher undertake a freedom to operate search. What you have to have in mind to do a good FTO, freedom to operate search, is the exact product or service that you're trying to clear to make sure it doesn't infringe. So you can't just have a generalized idea or a non-specific product that you're trying to clear, because patents are written very specifically, very narrowly. And if you change the material, it may be inside the claims or it may be outside the claims for a product, for example. So you have to have a pretty good idea what it is that you want to do commercially. The things that are the timing of when you would do an FTO, freedom to operate, should be probably early on, so you kind of get the general ideas that what's out there and covered. But then certainly before you launch anything commercially. The activities that a patent will prevent you from doing are making, using, selling, offering for sale, or importing someone else's patented technology. Just those 5 things: making, using, selling, offering for sale, or importing. So if you're not doing those activities, right, if you're doing research on something, or in the medical field, if you're developing a drug that requires use to generate FDA approval, you don't need a license for that. You don't need to be concerned about that. But it's when you're getting into that more commercial stage where you absolutely have to have freedom to operate. There's a whole,
If I could just jump in, just
yeah,
say.
go ahead, Kit.
Yeah, you kind of said that.
Yeah.
Our next Start Smart, which is on the 10th of October, is literally on how to protect your intellectual property, prevent that. And so we have a whole session on that. But one of the things that we do is we bring in, it's another K&L lawyer named Loren, who will show you how to do the search.
Right.
And she gives you some tips and what to look for and how to narrow it down. The other thing I would say, and I'm sorry, this is for the CMU students, we have a librarian that has developed considerable expertise in doing patent searches, and you just show up it's in the Wien Library. His name is Matt. And with your computer, and you think of competitors, and you look for, it's all done by Boolean search. So you need some keywords of everything that could possibly, different ways of describing it or is involved in it. And he will sit down and help you or actually do the search for you. But it's a CMU thing. I don't know. Stephanie, do you have anybody over at Pitt?
We do, but I'll have to get the name for, let me look it up and I'll put it in the chat.
Okay.
Cool. But but that's useful, and I think it's a great thing to put in the back of our head, is to make sure fairly early on, at least before you commercialize, Chip says, that you do some kind of search to ensure that you're not infringing somebody else's patent. And similarly, I take it, I mean, just if you're going to use, as long as we're on it, trademarks, I assume, Chip, you want to verify that as well. We might as well to close off on trademarks.
Yeah, that's a little bit easier search for people to do. Yeah. So if you're going to, a trademark is really just a brand, and any indicia that tells that you hold out as kind of shorthand of, this is who I am. I'm the source or sponsor of these goods or services. And we run into trademarks every day, right? The Nike swoosh, the word Delta, whether you're flying, an airline, or the word Delta if you're buying faucets for your new home, right? So trademark, two people can use the exact same mark, but you have to have some sense of, would the public be confused by my use of the mark? So again, trademarks is another thing that you can search at the USPTO under the trademark search. It's a good place to start. Then take your results and consult a trademark professional. They can help advise you from there if you find something that's close to yours.
Cool. So that's to make sure what we're doing doesn't infringe somebody else's. And then there's the third piece, which is making sure that you protect what you have, or deciding whether you want to protect what you have. Mm-hmm. And that goes to so what I always suggest to at least startups is to develop a strategy or a roadmap on your, at least the extent you can, and that can evolve over time, on how you intend to protect your IP. And that could be through trade secret, patent, copyright, whatever one of them you want to do, but it's important, and they can be inconsistent. Is the problem, because if you're keeping a trade secret that's sort of inconsistent with protecting it through patent. I don't know. Maybe it would take. We do, as Kit says, we do a whole nother presentation on this, but maybe it would be worth 3 minutes just on sort of highlighting each one of those as to what they actually protect.
Sure. So patents seem to be, so four kinds of formalized IP: patent, trademark, copyright, trade secret. They're the four of which there's bodies of law around and protection schemes available for each of those. They overlap if you think of them as a Venn diagram. Some things that are patentable are also trademarkable. There may be elements of copyright in them as well. So there's lots of ways to approach it. But patents protect ideas, right? They're novel, non-obvious ideas that you have. So useful, novel, non-obvious ideas. Trademarks protect the goodwill that you develop as a source or sponsor of goods or services. You actually have to be in commerce to have a protectable trademark. You can hold one until you launch, but if you're not selling goods in commerce, you really can't develop a trademark. But if that's your intention, to have a brand, then you probably have trademark protection. Copyright, original forms of expression fixed in a tangible medium. That's the legal term of what you can protect. So software, novels, movies, sound recordings, all of those things are copyright subject matter and can be protected under the copyright statute. And then trade secrets, sometimes synonymous with know-how, right? This is your secret sauce, your business information, your customer lists, those types of things that, as long as you keep them secret and they give you a competitive advantage in your business, is protectable as a trade secret. Each state has trade secret laws, and there's also a federal trade secret statute that's been adopted by over 40 states. So there's some uniform protection there as well. So those are the 4 categories. Depending on what you're doing, it's fairly, I won't say easy, but there's a hierarchy of things that you should be concerned about in your developing your IP and then thinking about the protection schemes available to you and how you might want to approach it. Does that help, Dave?
Absolutely, and perfect. And as for patents, there's a timing issue, right? Because you can inadvertently miss the opportunity and waive it forever, right?
Yeah. So when I said that in order for something to be patentable, it has to be useful is the first hurdle. Second is novel. So, and that's truly not out in the public domain, right? Never been done before kind of stuff. So that means you can't publish on it before you apply for your patent. You have to have the patent in place before you have public disclosure. The only exception to that is if you're only interested in getting protection in the US, you have a 12-month window after public disclosure that you can still file a patent for. But if you have a public disclosure of the novel aspects of your enabled invention, you cannot apply for protection outside of the US.
So I'll make the plea for the tech transfer office, and I'm sure Rhonda, you have the same thing too, is before you actually go, and because I know there's a lot of pressure on the PhDs and prestige and presenting at these conferences, but file a formal disclosure so they can file a provisional patent before you go talk, because you want to exercise as many of your options as you can. And the other thing I will just say from a business point of view, I have heard some of my startups say, oh, well, we had to get a patent because we're told investors didn't want to invest in us unless we had a patent. That is not the right reason to get a patent. You have to make sure it's worth the time and the money and is core to your business.
I totally agree with that. I totally agree with that. There's, what investors are interested in hearing is your what distinguishes your business and what gives you a competitive edge, as well as how you're going to make money. But how you're going to sustain that, what's going to give you a competitive edge, and a patent is one way to get a competitive edge, but it's not the only way. Mm-hmm. And so that's one tool, but not the end all of all. So just one more chip on the patent. If you commercialize before you get a patent, that'll screw it up as well, right?
That's correct. Yeah. So yeah, no sale, there are lots of bars to patentability: public disclosure, sale, offer for sale, right? All of those things.
So the non-public, not publicizing it, and it makes me think that folks, a good place to start when you're going to discuss your technology with third parties is to get an NDA, right? And it's pretty important for both the trade secret side and the patent side, as well as the protection for your business, right? Getting a good NDA from third parties, a non-disclosure agreement. Sorry for using the non-disclosure agreement. And one of the funny things about that, so one of the first contracts things that startups end up signing are non-disclosure agreements. And so let me maybe it's worth spending $1 million on that. And non-disclosure agreements actually only have they're typically maybe 3 pages long, but they actually only have 2 sentences that are important. One says thou shalt not disclose the confidential information, and the other says that thou shalt not use the confidential information for any purpose other than that which is intended. Those are the only two operative sentences. Everything else is fluff. Not really, but that's really the purpose of it. And it's really important as a startup to make sure that you get people who you're going to give your confidential information to sign non-disclosure agreements. Now, I have a caution, and the caution is that I don't believe in giving the secret sauce to people even under an NDA. I think that you ought to try very hard not to do that. The story I tell is the line I use is that if you have to enforce an NDA, that's like already having fallen in the bottom of the well and you're yelling from the bottom up for help. That's not where you want to be in life. So I prefer not to give the secret sauce to people even under an NDA. That's point one. Point two is that many NDAs have terms on them. They'll say, okay, I can keep it non-disclosure. I can keep confidential information for a period of time. People argue about 2 years, 3 years, 4 years, 5 years, whatever it is you're negotiating. My own view, and Chip and others may have a different view, is that actually if I give confidential information to people, to the extent it is at a minimum trade secret, it actually should never be able to disclose it. They should maintain it in confidence so long as it remains a trade secret. And I don't, because at that point, if I permit a third party to disclose that information, I've done two things. One is they're now disclosing it, which I don't want as a business matter. And as a legal matter, I think I probably have waived the trade secret protection. So I've actually, it's a bad, not a great thing. And people are pretty resistant to this. Chip, I don't know if you have a reaction to that.
No, I'd agree on the trade secret point. Yeah, it's a tough balance, especially for startups, if and with investors as well, or strategic partners that you're looking to work with. That's a challenge sometimes to get them to sign an NDA, right? Because if you go to pick a large company, Philips Respironics, and you've got the next best thing for whatever their product line is, and you want to talk to them about it and get them to sign an NDA, you don't really know what they're working on internally either, right? And they're reluctant to listen to your idea because it could not contaminate, but complicate their internal product development. So there's always a balance there, depending on who you're trying to share information with. But generally, Dave, I think you're right. To keep your secret and only disclose under terms that you're comfortable with for people that you're talking to. So
Can I jump in here too, just on sort of more on the business side? But we tell people, and for exactly the reasons Chip brought up, it's really hard to get people to sign NDAs. Investors won't sign them. And many of the big companies, I know IBM will not sign them. So what you need to learn to do is talk about what your business idea without talking about the secret sauce.
That's it.
All you need to say is using proprietary technology or patent pending technology that, and at very high level, using AI, machine learning, whatever you want to say. But then just talk about what the results are, what the solution you present. So that's how you talk about it with having to ask for the NDAs, because particularly in the early stages.
Yeah, I mean, I tell people that tell people what you do, don't tell them how you do it.
Right.
And that often will get us there. But if you get into strategic investors or joint development arrangements or things like that, sometimes they want to go the next route, and it gets into the complications that Chip was describing, and that is a challenge. So let me make a plug for, if you see yourself going in that, which is and it's a wonderful thing for young startup companies to be working with the larger organizations, right? I don't care if it's strategic joint development arrangement, I don't care if it's a strategic investment, all those kinds of things are great and wonderful opportunities. If you find yourself going into those, I would recommend you get a lawyer, because it's really important that you protect your IP going into those discussions. It's just that I've seen people make some mistakes in that area. Let me also take the other flip side. Chip talked a little bit about the contamination problem of large organizations are nervous about getting IP from young organizations, because then they're concerned that when they do something that they already have, they claim that they're fearful that there's going to be a claim. I'll take it the other way. I also worry for startup companies that somehow you're going to get contaminated with somebody else's IP, or claim that you got their IP or there's trade secrets, and then there's going to be a claim against you. So there's often a tendency to do a mutual NDA. Says, okay, well, I'll do one way to do both ways. And I tell clients, are you getting their information? The young companies, no. Then why do you need a mutual? You only need a unilateral. And don't take the other company's intellectual. If you don't need it, don't take it. Say, don't give me your confidential information. I don't want it. I don't want to be burdened with it. I don't be contaminated with it. So, the less important, but significant is ensuring that you don't get intellectual property or trade secrets from third parties. It's sort of the lesson of that. All right, those are the protection things, right? Anything else on the, I skipped through pretty fast the getting IP, making sure you own it and licensing it out. Are there any questions regarding, because we're going to lose Chip in not too long, and I'll make sure that we answer any questions relating to the process of taking IP out of the universities or that kind of licensing it from third parties.
And
Any
Dave,
questions?
even before we get to a question, I do want to just emphasize a point you made in the introduction, which is if you're not working by yourself, if you're not a sole proprietor, if there's two of you or more that are working to start a company, if you're founders, inventors, contributors, work product creators of any kind, you should have some agreement, written agreement between you on who's going to own the IP. And the easiest structure is for all of the creators to assign it to the company that you create. And Dave can explain why that's the easiest way to go. And it's best to do that at the beginning. So this is the starting smart part. So whether you're hiring someone like tonight, if Nicole finds an engineer who's going to help her implement her app, whatever, there should be an agreement between an engineer and your company, Nicole, to assign their work product to your company. So there's no question about what you can then do with it going forward. Absent agreements, oftentimes the creators own what they create. That's true for authors, for copyrighted material. That's true for inventors on patentable inventions. So you need that agreement to be at the beginning of who's going to own what before it's created. It's so much easier at that point. And Dave, I'll let you go from there.
No, that's great. I mean, actually, it's interesting. I mean, as an example, if you hire an independent contractor to develop software for you, and it's a technical matter, and you don't have an invention assignment, you paid that developer, but you may not own what that developer created because there's no work for hire. I mean, basically, they own it, and so you want as Chip says, you want an assignment of the IP to the company or a third party to make sure, or the company or wherever you want it, to make sure you own the IP. Absolutely essential. And I have war stories on that one too.
Also applies to interns.
Yes.
Yep.
Yep. Everybody.
Anyone who creates. Yep.
Yep. I mean, to give you something, I have been selling companies that we have had to figure out, because we didn't have all the assignments, whether that creator created anything material. And if you're having the discussion about whether they created was material, you're having the wrong discussion. It's just essential. And I'm putting aside the entity thing for a moment, because we'll spend a few moments on that in a bit here.
And just to follow up on that a bit further, if you sign have a confidential agreement with a company, let's say a outsourced software company, anybody who works for them is covered under that agreement, or do you?
Great question. So in theory, if I hire ABC Corporation to develop for me, and ABC Corporation has employees, in theory, the way it's supposed to work is that if my arrangement with ABC Corporation assigns it to me, then I should have the assignment, and the people who worked for ABC Corporation should have assigned it to them, and they should have separate agreements with them assigning it. As part of you, and you would typically ask for a representation in the agreement that they have all those assignments, and you might even ask them for a form of that assignment. And you will actually typically not just have an assignment, you might even have an indemnification by them to indemnify you for a failure to do that, because it's really important. Your points are well taken and really important. One other tiny little legal point is that, and the Chip is it's important to have an assignment, a current assignment, not an agreement to assign someday, but an assignment that says I hereby assign. And I don't want to be lawyer-like, but it just at present I assign. Just really important.
David and Chip, what do you do if you're just a student team that has an idea, you're not sure if there's enough commercial potential that you want to go ahead and form a company. Is there some other way to sort of assign IP or have an agreement amongst yourself about what happens if you get to that stage, or is really, do you need to go ahead and form a company to assign it to?
You want to take it first, Chip, or you want me to take it?
Go ahead, Dave.
So, I mean, you don't have to form an entity.
Mhm,
So, I mean, it's easier because there's an entity to be done.
mhm.
But you can assign it to, I mean, typically with the student things, in my experience, there's one person who's taking the lead. And so you can have it assigned to the student who's going to take the lead and going to run with the project. So if I'm leading and there's some other students who are not going to be involved in it, then we can then they can assign it to me. Short of that, then you can have an agreement among the agreeing as to that they will assign it, notwithstanding my present intent, but they will assign it to the party that they agree upon, as long as there's an agreement. The point is to have an agreement among the principals as to what they're going to do going forward.
And it's necessary to have some sort of a consideration if you're going to do that?
Well, if all of them are doing it, it's pretty, the consideration is probably all of them doing it. So I'm a little less concerned about it. And so I'm not too concerned about the consideration in that regard.
So this comes up often when you've got a class project.
Mhm.
And usually 5 people on the team, and then one person thinks, I want to take the next step and commercialize it. And so the importance is to do it before everybody goes away, and then you have trouble finding them.
Correct.
And what I just tell the students, don't get difficult about this. If you're really not interested in exploring it, just wish somebody well, and usually they'll give you credit for the initial contributions you made, but almost always what the actual content is will change as they evolve. So don't get overly hung up that you're giving away fortunes by assigning it to your classmate.
And I'll add one more, and please don't get too fancy, which is don't be offering percentages of the business or anything like that.
Yeah.
Because that gets really cumbersome and complex, and that just creates issues later, at least in my experience.
Mhm.
Other questions on that piece? Anything else on the tech transfer side that you wanted to chat about, Chip?
Not really. I think as long as you're doing your due diligence up front, know what you own. So one of the most common things, at least in university settings, and this I know occurs both at Pitt and at CMU and other universities. Oftentimes the ownership of what you're working on is determined by where the funding came from, right? So if you're working on a grant, a federal grant, that federal grant comes with strings attached to it. So if you're a student, inventor, creator that's working in a professor's lab, the grant is funding your work, that work product is encumbered by the terms of the grant, right? That says the outcome has to be assigned to the university because that's what the taxpayers gave the university the money for, right? I'm simplifying here, but the whole point is follow the money, right? Who's paying for what it is you're doing in your role, whatever it is that your role is, because there is encumbrances, there are strings attached, there are obligations to meet based on where that funding comes from. That's probably the easiest way to think about it. Same thing if you're on a sponsored research project at a university. If Apple's giving us $1 million for a particular lab, Apple may have some rights to what comes out of that lab. That's just kind of a generalized statement, but that's often the case. That's one reason they give money to universities like CMU and like to Pitt. So just be aware of the environment that you're operating in, who's funding the work that you're doing. If it's totally outside of those roles, there's no strings attached, no obligations, then the creators, who actually creates the thing, is generally the owner or have rights to it. Then that you kind of start from there. So.
Good, thank you.
Would it be helpful to quickly discuss the kinds of patents that are available?
Sure. I think Sean mentioned he was working on a provisional. So at least the generalized scheme for patent protection is your first application oftentimes is what's called a provisional patent. It's kind of a placeholder, if you will. It's low cost, doesn't have a lot of requirements, and it will hold your place in line with a filing date and an application number for 12 months. It will expire in 12 months if you do nothing else. No one will ever look at it. It'll just essentially go away. Within that 12 months, you can file what's called a non-provisional application. The Patent Office is very creative with their terminology. A non-provisional is the formalized document that will get examined, and it does have a lot of requirements, and it's, you know, it's probably in that $8,000 to $10,000 to $12,000 range to get a non-provisional patent application prepared by a patent agent or patent attorney. But that's within that first 12 months of having that provisional on file. The beauty of having a provisional on file is you've got your place in line, you've got a filing date, and now you've got 12 months to figure out whether it's worth spending the additional money to turn it into a non-provisional. And what you're trying to figure out is this commercially viable? Is it patentable? What else my competition is? How am I going to make money on this thing? What's my exit plan? So hold your place in line, figure all those things out, and then you have to decide to spend the money and move it into the non-provisional stage. Non-provisional patent will get examined against the prior art that existed out in the world prior to your earliest filing date, and whether either it meets all the requirements of patentability, there'll be some back and forth with the examiner, and ultimately may or may not issue as a US patent. The day it issues is when your patent rights, when your enforceable rights come into being. So there are other types of patents. We don't run into them too much. Plant patents, very rare in the Pittsburgh area, mostly for new non-asexually reproduced plant species or inventions. And then design patents, which are really a little bit of a hybrid between a patent and a trademark, if you will. So it's actually how something looks in 6 different views, this particular design. Again, a rarity, not something we see a lot at CMU.
So business method?
That's just a subset of a non-provisional utility patent, right? Okay. So that's just a classification of subject matter, if you will. Yeah, so you can patent articles of construction. Help me out here, Carol. Methods, processes. I mean, they
composition's a matter.
Thank you. Yep.
Yeah. Yep.
Cool.
Is that what you're looking for, Dave?
That's great. Thank you.
Yep. All right, I am going to drop off, so I'm not late for my next one. Thank you for including me. And say I'm leaving one good patent attorney online with Carol. If you have questions, I'm sure she can help you out.
Thanks, Chip. Really appreciate it. That was great. Thanks.
All right, take care.
Let's morph a little bit into, unless there's something else you'd like to talk about, maybe corporate formation or entity. Is that maybe a good thing to sort of touch on? Because now we know what we're doing on IP, it's good to know where we're going to put it. And let me start with why we form an entity, because it's really a couple good reasons, but the best reason, not the best, a good reason is limited liability. It's good to, one of the things that our system allows us to do is limit the liability of the individual. So owners of the enterprise don't have liability for the debts and liabilities and obligations of the entity itself. That's kind of nice. And so that is worth remembering. So if, for example, you form your entity and it goes bankrupt, or it runs into it fails and you owe investors money on it, at the end of the day, nobody can go into your pocket. They can only look to the entity. That is worthwhile. That is worth remembering. Now, there's a couple exceptions to that, which I want to spend one moment on. One is that you have to adhere to the corporate formalities. People can what's called pierce the corporate veil, which means if you don't actually Even though you form the entity, if you don't pay attention to the entity, then people can pierce the corporate veil. They can basically look at it and say, you are the same as the entity, you as an individual. How do you do that? You have to have separate bank accounts. You don't commingle funds. If you put money in and out of that corporate account, you sign things on behalf of the company. You and so you execute things on behalf of it. You sign and you have separate bank accounts. Those are the principal ways. Keep minutes. Have board meetings. To really treat it like a separate entity, a legal entity. So that's part one. Another way to screw up personal liability is to sign personal guarantees. So, if you sign a personal guarantee, then you are personally, it's almost tautological, and I guess it is. But people forget that, and they sign personal guarantees, particularly as the principal one they start with is a lease, where you lease some space because you have this business. The landlord says, well, there's no asset in that entity. So, and they say, I want you to sign personally, and you sign the personal guarantee, and that's probably not where you want to be in life. So, to avoid personal guarantees, at least know you're going to do it. So forming an entity is principally to protect liability. So that's point one. What kind of an entity? Great question. And there's lots of choices, too many to imagine. For-profit enterprises, we typically had come down to 2, maybe 2.5. So there's C corporations, which corporations, which like has shareholders and the ones you're used to, shareholders and directors and the corporation. Pretty straightforward. And then there's limited liability companies, which instead of shareholders, the owners are called members, and the people that run it are called managers. Same kind of concept. One's limited liability companies, one's corporations. And then the half I mentioned was an S corporation, which is a corporation but taxed like a partnership or limited liability company. So it's a hybrid. And we do a whole nother little start smart on which entity, choice of entity, and which one to do. But I do think it's important that the main point I want to make here is that there are some decisions to make in doing that. So don't just rush out to do one because everybody else does it. Sometimes I hear people say, oh, I'm just going to do a limited liability company. I'm just going to do a corporation. And there are pluses and minuses to each one. And so it's a thoughtful, thought out decision, not one to be done just because my friends did it. There's also, there's also, I've assumed in that discussion that there's for-profit, there's also nonprofit. And so there's nonprofit corporations, and there's some, I'll call it hybrids, which are benefit corporations that are more of a for-profit, but have a more social enterprise kind of implication. So there's a question regarding different states. Which state, how do I know what state to incorporate in? So let me spend 1 moment on that. If you are from around here, and you're going to get, let's say you're going to get VC funding, or you're going to go get, if you're going to get VC funding, then I would go straight to Delaware. Do not pass go North like 200. I would go to Delaware. And the reason I picked Delaware is because venture capitalists and third parties are comfortable with Delaware law. Delaware has a well-established framework within which corporations can operate. They understand the case law, and so people are comfortable with Delaware. So I would start there. If, on the other hand, you're doing a company that's mainly going to do, you're going to be a Pittsburgh or Pennsylvania-based kind of business, you're not really going to do much elsewhere, then I do a Pennsylvania corporation. Generally, nowadays, I find myself doing more Delaware corporations or entities. So I would be inclined to go there, especially if you're going to get outside funding. Did I answer the question? Let me do 2 more seconds on corporation for there are some. Kit, did you have a question?
No, what I was just going to say is just to tell people that we have the next Smart Start is on intellectual property. The following on after that is we have 2 sessions on company formation. The date is October 27th, beginning at 5 o'clock. And David will be going through in much more detail about all the different types and the pros and cons. And sort of, if this is the case, that, this is what you want to do. The following session on November 10th, anybody who is thinking about forming a company can sign up to participate in a workshop. And Stephanie gets her law students to volunteer. That anybody who signs up, you will be assigned one or more law students who will work with you to come up with a roadmap, pretty much of this is after listening to you and what you're doing and what your plans are, that will suggest whether you do a C Corp or an LLC, or maybe there's some other form. Here's some things you need to think of for your bylaws or operating agreements. And you're not obligated to form the company right away, but when you go in, you're an informed consumer. You already know all the things that you have to decide. And so you know what you want to do. And lawyers' time is money. So you're an informed consumer, and so it'll make it much easier. Lawyers love it. So
You get them to sign an NDA first?
No. So anyway, so the 27th is the lecture that sort of goes through all the things that you need to think of. And then the 10th, November 10th, is the actual workshop. And we've had sometimes the law students stick with you as you go through, and they can't practice law, but it's overseen by lawyers, David and Stephanie in particular. So you're getting good advice or direction. I can't call it advice, can I?
Yeah, we call it a roadmap, and a legal roadmap, and it gives you've thought about all the ramifications of your formation.
Yeah.
And when I talked about LLCs, and some of the considerations include tax. LLCs are pass-through, C Corps are not. There's the flexibility, and there's some others as well. So we'll go through all those when we do that. And the one lesson, by the way, is that you can go. It's much easier to go from an LLC to a C Corp than it is from a C Corp to an LLC. So if you're going to make a mistake by forming an LLC, and then we can form the C Corp later.
So
I want to go.
Philip has his hand up. So Philip, unmute and ask your question.
Yeah, hi, Philip Rhonda here. I had one question on the entity kind of topic that we discussed earlier. So if a company has filed an IP or provisional patent through CTEC, the current agreement is you get 6% or give the university 6% equity in return for them handling the or deferring the patent costs. That liability, is that with the founders or the entity itself or the company?
That'll be with the licensee or the entity. When the entity will license generally, the entity will license the technology from the university and will have that liability to the university, not the individuals.
Okay. Yeah, it just comes up in case the commercialization doesn't make sense at the end of the day, or we just pivot here, pivot there, or we go bankrupt, for example, for some reason.
So what you would typically do is you would if it goes south, you'll terminate the license with the university. The university will terminate the license. It'll go take back the technology and hopefully license it to a third party to commercialize the technology.
Okay, very good. So, for example, those law costs wouldn't then, if the company goes insolvent, wouldn't then fall on the owners?
No.
Okay.
No.
So I just want to make sure you answer Lisa's question.
That was where I was going next. Exactly.
Okay.
Yep, perfect. So Lisa, can you ask me? How do you know I was going? You're good. Lisa, maybe do a little bit more on your question.
Well, we're heading in the direction of taking it to market, but we're not exactly ready. And so we need investors to finish our project. But we wanted to split their medical software. We wanted to split the company because if you have investors who are interested in the one piece of software and they would be entitled to the whole company, correct?
Yep.
So therefore, we were thinking of splitting the company in two. But we sort of already established the name of the company, and now we're all a little bit up and down over it.
So what is there, a couple questions, and it's just sort of, if it's okay with you, we're going to use this sort of a springboard for some other, so what kind of entity is it?
Medical software?
No, I'm sorry, C
Oh.
Corp.
Oh, and that
LLC.
we're making it an S Corp.
You've already formed it or you haven't formed it?
We have not formed it. We're in the process. What we have done now is the NDA. We're forming the S Corp, and then we were going to meet with our investors.
Okay. So step one is it's unlikely that the S Corp choice is one that needs to be thought out because, because S Corp has severe limitations, including the nature of the investor, the nature of the shareholders, which can only be individuals, can only have one class of stock, et cetera. So it's difficult typically to have outside investors in an S corporation. So think about that decision in the first place. I typically, because as I say, the two classes of stock will often mess that up. So if I get investors, usually it's an LLC or a C Corp. So start there. The second question is often if the two pieces of software are related in some way, and I don't know if they have common code or what it is, but
they do not.
They do not. They're two separate businesses entirely, two separate enterprises. Say it's two different, nothing in common.
Nothing in common.
So why were they together in the first place?
Well, because it was just a software company, All
right. Okay. Good. So the reason is because one of the things the investors care about is making sure that they get the whole ball wax. Sometimes I have people who say, okay, I want to separate out this indication in the medical industry or that application as it relates to software or whatever, and separate it out, right? And I'm only going to sell stock or interest in one piece of it. And that's typically not a great plan. Typically, investors want, typically not a great plan. The investors want the whole business. So if they're totally separate and have nothing to do with each other and basically just happen to be together, then okay, no worries. But if they're somehow related, then I would think hard about separating. That's point one. It's point two. Point three is that what investors are buying is the business, but they're also investing in people. And so part of when you separate it out, the question I would have in the investors, what is the founder's interest in both companies? Why am I going to get the founder's real or the people who are driving its real interest in this company? Because now there's another company. So what am I not getting? And for them, right? So that's that question you'll have to address.
The reason that we wanted to divide the company is because she is separating the stock by how much time you've invested in it. So the one piece of software, 5 engineers have 8 years. The new piece of software only has 2 years. So what the majority holder wanted to do was separate it so that the people who have 2 years invested in the one type would have equal amount of stock, but it would not be fair to give them the same amount of stock after they have worked for eight years on the other piece of software. So if she did it she did it because it was a way for her to divide the stock.
Yep, I get it. Well, again, I understood. And that is one solution to that problem. And if you're forming the companies ab initio from the very beginning, and they have nothing related to each other, then that's an okay solution. I mean, you're not really dividing the stuff. You're really creating 2 separate companies from the beginning. Then that probably won't.
Correct.
Then there's no reason you can't do that. If I'd have a very different view if it was already together and then you were trying to split it apart. But if you're forming it today from the beginning, sure, why not? That works. I would caution, but one interesting part that is a subset of that, which is that as you're forming this company, it's for a global point for everybody, we talk a lot about vesting stock and making sure that stock vests. So for example, in your example, if we have people that are now getting their stock, but then the next day they walk away, do they walk away with that stock, or does it vest over time based upon their performance going forward? And that's really important. I mean, it's not funny to give somebody 40% of the stock, then go to work for Google tomorrow, and now they work for Google and they own 40% of your stock. So we often vest founder stock over time based upon performance going forward. Really, and that's a pretty fundamental point.
Okay, thank you.
Mm-hmm.
So David, there's a question in chat and I'll just read it. I have a question. Thanks for your kind explanations. Now I am trying to find a customer company and license them. Since I will be the people who is going to contact, pitch, and get the company's interest and finally make this idea profitable. Am I able to take more shares or get a salary if it finally works? Because the patent is held by 3 parties, me, my supervisor, and CMU. And I currently work in CMU as full-time, or should CMU license it to my startup? So they're confusing sort of the company ownership, I think, with the patent rights. So
from the little bit I heard, it sounds like what should happen is the traditional way would work, is that a company would be formed, the technology would be licensed to the company, and then on behalf of the company, you would be going to the third party to commercialize it. And you would be receiving stock or equity in that company based upon your performance and services to the company. And so, for example, in that startup company, the professor and you and whoever else would get some stock based upon what you've provided so far and what you're going to do in the future. And you would license the technology from the university. It's owned by the university, and then on behalf of the company, that startup, you would be going to commercialize it. That sounds like the structure.
yeah, so you can get a salary, and if you're actually working on it beyond the patent itself or the technology, then you would actually get probably entitled to more shares. But there's a tool that can help you figure out how much equity everybody should get in the company.
Right.
We can use.
Yep. And you got to allocate it amongst them. And that's one of the questions, which is deciding how much everybody's going to get, and you're going to vest it over time. And on my vesting point, I'll give one more point about that, which, there's a question is, even after it vests, do you want a right to buy back some of that stock?
Yeah.
When somebody leaves with vested stock. So maybe you have a right to buy some or all of the stock that's even vested at the then fair market value. So you don't have somebody, again, from Google owning, I always pick on Google, I don't know why, but having somebody from Google owning a large portion of your stock, even if it's vested. So maybe you have a right to buy at the then fair market value, so that they don't continue earning, sharing in the upside, while the people who are there lose that benefit.
And it will make a huge difference to investors.
Yes.
They want the stock owned by people who will,
who are driving the value.
Driving the value.
Yep,
and
absolutely.
we've actually seen that they would say, we'll invest in you, but you got to fix that.
Yeah, we got one today. We got one today where the investor said you need to buy out the former founder before I'll put it in. Got to get rid of them. And that's a very difficult conversation. It's much better to have had in the document the right to buy them originally, rather than have to go to them later and say, I'd like to buy you out. Those are 2 different discussions.
Right.
Yeah. And that's anyway. Okay. Other questions on formation kinds of things? Why we do it? Okay. Other subjects, raising capital. Do you want to spend one moment on raising capital, forms, et cetera? Just, it's important, but I don't know. There's different forms. There's common stock, there's notes, there's safes, there's all kinds of neat stuff. Convertible debt. The most common for various startups, we probably should spend a moment, are convertible debt. because that's really what you typically do as a startup. And you issue people convertible debt, and convertible debt is simply borrowing money. So that sounds nasty, but that debt will convert to stock or equity of the company based upon some different scenarios. Scenario one being you raise additional capital, and so it converts at a discount typically to that raise. So to be more precise, if I get convertible debt called of $100,000, and then I raise money later, $1 million at a $5 million valuation, then my $100,000 debt would convert at that $5 million valuation at a discount of 20%, call it, so at a $4 million valuation. So the benefit to the convertible debt is that you don't have to decide on the valuation today, and so you do it later, and presumably what that valuation will be at a higher valuation, which means I give up less money later, less equity later because the higher valuation. So I'm not only not deciding on the valuation today, but I'm waiting till later when arguably that valuation will be higher. So convertible debt's actually a nice vehicle for startups, and that's typically what they use. The trouble is that if you can you can overdo it, and you can get too much convertible debt, so that when you eventually convert it, you end up giving up too much of your money, your company, because you got too much equity, it turns out. And so we had a client once who raised $9 million of convertible debt, and it turns out that's too much. So, but anyways, so that's convertible debt. It's a nice vehicle. The thing that you see often today is sophisticated angels or investors who do convertible debt. They often now want a cap on the valuation. So they'll say, okay, I'll do it, but the cap on the valuation on the conversion will be, call it $2 million or $3 million, and they'll negotiate that value. So that is something that you see common today. So you got to be aware of that. Similar to that are safes, which are kind of a strange animal, and they are just like convertible debt, safe notes, except that they actually aren't debt. They don't actually come due. They're an agreement to pay people money, and you pay it either on a sale or you pay it on they convert. But it functions very similar to convertible debt.
No interest, right?
They sometimes they don't pay interest, but they do sometimes accrue, and so have an increased amount upon conversion. So it functions like interest.
Okay.
But think of it as a contract right, but it functions like a note. But the principal difference being that it doesn't have maturity. So if you don't sell and you don't convert, then and raise additional capital, it's never due, unlike a convertible debt. Okay.
So
they're pretty.
Yeah.
Go ahead.
I was just going to add one thing that I see sometimes confusion or people don't understand. When you hire the lawyer is representing the best interests of the company. They are not your lawyer. And so there's people somehow think, well, why weren't you protecting me? Well, the job is to protect the company, although you see that as your company in there too. So you just have a different role.
And that's correct. That is very true. And to take us to its extreme, I have been in board meetings, where we have fired the founder who hired me originally, to take us to most extreme. But your interests are typically aligned with the company at the beginning, and they come misaligned generally when the VCs or otherwise basically get control of the company. But largely they're aligned until about that. But you are absolutely right, Kit. It is really important that people understand the representation, and corporate counsel does not represent the individuals.
Yeah. So I'm going to give you a minute to think. If you have one last question, I'm going to make my final advertisement here for, I've given you the lineup that's coming up on our Start Smart. October 6th is intellectual property. 10/27 is the company formation seminar, and then November 10th is the workshop where you're going to get teamed up with a lawyer, law student. The last one is taking place during Global Entrepreneurship Week, which we do jointly with Pitt and been doing for a number of years and offer a series of sessions. And during this one coming up on Tuesday, November 15th, again at 5 p.m., a Start Smart on building and leveraging your professional team. So this goes beyond your co-founders, and we talk about, you know, how to shop for a lawyer, when do you get to bring an accountant on board, particularly about how to recruit and manage your advisors and the different roles that they play. So that's the last session for the semester.